Well, good afternoon, everybody. Hope you can hear me. We will go ahead and get started. We are having a slight technical difficulty with Tiffany's mic, but hopefully we'll have that fixed by the time Tiffany starts presenting. If not, we'll just skip over her and come back. That's how this will work. So I'm going to introduce myself. I am Paul Goeringer. I'm the Extension Legal Specialist here at the University of Maryland. And we will go ahead and get started with this Right to Farm webinar. We're going to kick things off with Ashley Ellixson. She will be starting us off kind of discussing what right to farm laws are and what they are. And Ashley, if you'll give me a second, I will go ahead and hit the record button.
Sounds good, Paul. Just let me know when you're ready to go and I will begin.
Okay, start whenever you're ready.
All right, and again, my name is Ashley Ellixson, and I am also a legal extension specialist with the University of Maryland, and I'll go ahead and get us started with what are right to farm laws and why are they in existence, and kind of go through the overview of what these statutes are. So I'll go ahead and skip through this since we are starting a little bit later. This is just a disclaimer. Even though we are all attorneys today, this is purely for educational purposes, and this is in no way creating an attorney-client relationship. Just a little disclaimer for y'all. So what are right to farm laws? Well, we're going to go through the history of right to farm laws, kind of how we came to be today, why the states have them, and then what do they do? So the history. So let's take it back to 1911. And we're going to be in Maricopa County, Arizona, where the Spur family began farming about 15 miles west of central Phoenix. If this starts to sound familiar, it's because it's actually a real case. In 1956, the Spur's predecessors began developing feedlots. In May of 1959, Del Webb began planning an urban retirement community to be known as Sun City, about 10.5 miles north of Spur's feedlot. If you're familiar with Sun City, it's a very large retirement community and still in existence today. So this is what Maricopa County, this area looked like in 1962. You have Spur Industries right down here. Pretty small, and then about 10.5 miles north you have Sun City. And this again is 1962, just to give you a little visual. So by 1965, the Del Webb community had expanded, coming within 500 feet of Spur's feedlots. So what does it look like now? Well, here we are. We have Spur down here, and at this point, Sun City had basically taken up that entire next block here between Peoria Avenue and Olive Avenue. So as you can already guess, this is going to cause some issues. What are those issues? Well, you have a large neighborhood abutting a cattle feedlot. It's going to cause quite a few things. Smell of manure, abundance of flies were affecting the current residents because at this point people had already moved in. Del Webb ended up bringing a suit against Spur for an injunction, which have forced Spur to halt or move its business. So one way or another, they wanted Spur to move. Ultimately, the court granted the injunction, but required Del Webb to actually pay for Spur's cost of moving or shutting down the operation. So whichever Spur decided to do, the court actually made Del Webb pay for this. And this is all, of course, before right to farm laws. So there was nothing that Spur at the time could use as a defense to these nuisance claims. So prior to right to farm laws, the court actually had a choice as to what it wanted to do and was not required by law or statute to deny Del Webb's injunction request. So the question which actually needed to be answered in the lawsuit in order for the court to come to its ruling was, may a lawful business that becomes a nuisance due to a subsequent residential development be required to move or cease operation? So as you can see here, this was Spur had already existed. Then the residential community began to be built and moved into where Spur was. So these were the facts of the case. And then if the nuisance may be moved or ceased, may the developer, Del Webb in this case, be required to pay the nuisance spur the cost of its move or cease operation? Well, the court answered yes to both of these issues. And their reasoning was based on spur was a public nuisance, which means it's a danger to public health because of the large community that Del Webb had created. It had so many people already living there that it was actually causing a public nuisance at this point, so not a private nuisance. And it was not due to any wrongdoing or unlawful acts by Spur, since Del Webb knowingly, again, came to the nuisance. And if you go back and look at cases in this era, you're going to see this type of language. So Del Webb moved into where Spur was, so it actually moved into the nuisance that was already there. And then as a result, Del Webb, again, was required to pay Spur all their costs of moving or shutting down, which again is probably not what Spur necessarily wanted. They probably wanted to continue existing because they had been there since 1911, and we're looking at 1969 or 1972 at this point. But at least they weren't required to pay for
Ashley, you're breaking up.
as a whole. I got kicked out. Sorry, guys. Can you all hear me again?
Yep,
Okay.
we can hear.
Yep, I apologize. For some reason, I get kicked off of here. It's not due to my internet. I don't know what it is, so apologize to everyone for that. Okay, so we got to the part where it was because of cases similar to Spur that states recognized this issue, that there were going to be urban encroachment on top of agriculture operations, and this issue was going to continue to arise. So because of that issue, legislatures in all 50 states at some point since the 1970s, 1980s, have passed right to farm laws as a result. So this is actually this is, I think, a 2008 or 2006 picture of Del Webb. So as you can see, it's definitely a metropolis at this point. If you've been out to Maricopa County or Glendale, where the Cardinals play, this has definitely grown up. And you're going to see a lot of this all over the United States. So what are these right to farm laws? Well, right to farm laws are statutory rights that are written laws set out by local or state governments which bestow a right but is secondary to higher constitutional laws. And I believe Paul might be addressing, there's been some right to farm constitutional type amendments that have been offered up and whatnot. So he's going to address that later, but for these purposes, we're just looking at the state and local statutory rights. So generally, right to farm laws are going to address 7 topics. And I'm going to have to give credit to Tiffany for these. She kind of narrowed it all down, so she did a really good job with that, so I went ahead and took that from her. So the right to farm laws are going to address whom does the statute apply to. So generally, most right to farm laws are going to define agricultural operations to which the statutes apply. So in most cases, it's going to be your more traditional farming operations, so practices like crops and livestock and dairying or breeding and raising animals. And then in some states like Hawaii, they actually protect farmers markets. And Nebraska is actually applied to grain elevators and warehouses. So every state is going to be a little bit different, but this is a general overview. What claims do the statute bar? So this is interesting. So in the case we talked about with Spur, the right to farm law would have barred the nuisance claim. There was actually a case out of Texas where a plaintiff sued after manure ran onto his property and was trying to also file a suit claiming trespass. And in that case, the court said that the right to farm law also apply to trespass. So you're going to have Oregon, California, and Hawaii have found that the statute actually bars your nuisance and your trespass claims. But again, this is going to be very state specific. So you're going to want to make sure to look at your specific state to see if it's going to only apply to nuisance or nuisance and trespass or maybe other claims. The time and operation requirement. So states vary widely in this. So you have some states that require that the operation be basically in existence for maybe a year or up to 3 years even, or you have some states that don't speak to this requirement at all. So again, this is going to be a state by state specific requirement, and make sure to check with your state before basing anything off of this. Compliance with generally accepted practices. So many states are going to say that if a farm or an operation is going to use this statute to help bar a claim brought against them, they're going to have to be practicing these generally accepted practices. So many states, their legislatures have statutes that say, you know, in a dairy, these are the generally accepted practices. If you're growing, if you're raising livestock, these are generally accepted practices. If you have a corn and soybean operation, these are generally accepted practices. So you want to make sure that if your client is, say, one of these people, that they're following their state's generally accepted practices. What about change in operation? So this has been interesting. Some states actually address this. So what are change in operations? Some say that it could be technology advancements. Some states say that it could be, say you decide to diversify your operation. You're a dairy operator and you decide you want to start raising your own calves. You used to not, but now you're going to expand and create a whole nother calf barn. Or maybe you're a livestock operation and you're going to also start farming your own grain. Some states are going to allow this. Some states don't even address it. But again, this is generally right to farm laws either do or do not address something like this. And then in that case, they vary state by state. Attorney's fees. So even if, say, the farmer or the operator does bring the right to farm statute as a bar to the claim and they win, he may or may not, depending on which state he's in, be required to pay his own attorney's fees. In some states, they actually allow the defendant to, in these cases, apply to have the plaintiffs pay their attorney's fees. So again, it's going to be state by state specific, and you're going to have to look at your own state statute for this. And then what are the limitations? So right to farm laws are not absolute. They are going to provide no protection in some cases, some statutes, if the farm is acting in a negligent manner or violating state or federal regulations, such as the Clean Water Act. So if a farm is being negligent in the way they handle manure and they happen to be in violation of the Clean Water Act, they may not be able to bring this statute to bar a claim. So that's something else that the statutes will talk about. This isn't an end-all be-all. It is going to be, they have to be in basically good standing to be able to bring this bar. And I think that's the end of my part. And if Tiffany's mic system is working, I will hand it over to her. And if not, I will hand it to Paul. You there, Tiffany?
One thing before Tiffany gets started, I will tell everyone we do have a question and answer box. Please type your questions in. I forgot to say that at the start. And Tiffany, is your mic working now? Okay. Hold on for just a second and we will get Tiffany's mic working. Hey, Ashley, there is a question there. Why don't you handle it while we are waiting on to get Tiffany's mic to work to save us some dead air?
Sure. So Tony asks, is there a model statute? I know it varies state by state. So the topics I just went over, basically every statute is going to address this topic in one way or another, or not at all. But these are basically the maximum amount of topics that the statute would address. And if there's an outlier, I apologize now, because there are 50 of them. But these are basically it. If you go to your own state's code, you'll be able to find one, or Google. But there technically isn't a model statute, like one that's like a fits-all type situation.
Okay, Tiffany, try talking now.
Okay, can you hear me now?
Can everyone hear Tiffany this way? Please type in the question box.
So sorry about this, guys.
Okay, Tiffany, we can hear you. I will get your PowerPoint up. Okay, it's all on you now,
Perfect.
Tiffany.
All right, well, leave it to me to be the one with the technical issue. If it can happen to anybody, I will be the winner of the contest. So Ashley just gave an overview kind of what right to farm statutes are. What I want to talk about today is some recent litigation and legislation that has occurred related to right to farm statutes. So when I say recent, I should probably clarify it's relatively recent. To look at these, I actually went back about 2 years. And so this is kind of what's been in the news the last 2 years. Here's a roadmap of what I'm planning on covering. The first thing is some pretty recent swine farm lawsuits in Indiana. The final one of those actually just ended in the last couple of weeks. Then we're going to look at constitutional challenges that have been made to right to farm statutes in Indiana and Missouri. Then we're going to talk about if the right to farm statutes protect the right of a farmer to grow a genetically modified or GMO crop. An interesting question that has come up is whether right to farm statutes will protect marijuana farmers in those states that have legalized marijuana. And then we're going to look at 2 pieces of legislation. One is an amendment that was recently done in New Mexico, and one was a bill that failed, but is still interesting regarding application to wind farms. So first up, we're going to talk about the Indiana swine farm lawsuit. Back in 2009, there were 5 lawsuits filed against swine farms in rural east central Indiana. The lawsuits were brought by plaintiffs who were neighbors of the farms, and each of these neighbors had the same attorney. The descendants in the case were all the same as well. Maxwell Farm was the contract party to each of these farms, and then there was individual farmers. So a lot of times what will happen is there might be an individual farmer there in Indiana who contracts with Maxwell Farm. Maxwell Farms will send the pigs to the farmer. He raises them. And so in these cases, both the individual farmers and Maxwell Farms were defendants in each of the 5 cases. So in those lawsuits, the claim was nuisance, and the primary facts that were used was the odors from the hog production. And so in the lawsuit, the plaintiffs claimed that the odors substantially interfered with their ability to use their own property. And so those lawsuits were filed, like I say, back in 2009. So during discovery, so after a lawsuit gets filed, the discovery period occurs, and that's where things happen like they'll send out interrogatories where the plaintiffs have to answer questions, and they'll take depositions where the plaintiffs are sort of questioned under oath. In these cases, the plaintiffs testified in their depositions that the odors did not impact them on a daily basis, despite the complaints that they filed stating that they did. They also admitted that they really had no knowledge of the complaint, the allegations that were in the complaint. And then the plaintiffs admitted, multiple of them, that the allegations actually came from their attorney. So obviously that was a pretty important piece of evidence for the defendants in these cases. So the defendants took this information and the Indiana right to farm statute, and they filed a motion for summary judgment. And what summary judgment basically means is there's not really a dispute of facts. The facts have all sort of been agreed upon by the parties. The only question is, how is the law applied? And so here the defendants argued that the law made clear, the right to farm statute, made clear that they had a defense to these lawsuits. All the cases have been dismissed. Like I say, the 5th case was actually dismissed within the last month or so. So in each of these 5 cases, the defendants were successful in defeating the nuisance claims. Now, an important issue that Ashley mentioned earlier was that some right to farm statutes have attorney fee provisions. In Indiana, their statute does not. And so what that means generally in the law, when you go to court, win, lose, or draw, each party pays for their own legal fees. And so in this case, because there was no attorney fee provision to change that in the right to farm statute, even though these individual farmers and Maxwell Farms won their cases, they're still on the hook for those attorney fees. If any of you guys have ever had to pay an attorney, those fees were likely in the hundreds of thousands of dollars. So it's real important for people involved in policy and lawmakers to really think about the need for those attorney fee provisions in right to farm statute. The next piece that I want to talk about was a recent constitutional challenge that was filed in Indiana. Once again, we are dealing with a neighbor suing a hog farmer, but this case is a little bit spicier. We have some more facts. The first thing here is the plaintiff is also a farmer. And so it's not like in the Dell Webb case that Ashley mentioned where it was some, quote-unquote city folk who moved out to the country. Here you've got one farmer suing another farmer for nuisance. Even better, the 2 farmers are cousins. So you've got one farmer suing his cousin who owns a swine farm down the road. Next up, the plaintiff alleges that the snow is so bad his wife moved out of the house. And at this point, when I was working on my PowerPoint, I just thought, this sounds like the perfect country western song. So these are the facts we're dealing with here. The hog farm that was owned by the defendant had been built 2 years prior. There was 2 buildings total that housed about 8,000 hogs. So the allegations in this suit, so not only here, the plaintiff filed a nuisance claim, but because they suspected that the farmer was going to raise right to farm as a defense, they also challenged the constitutionality of the right to farm statute. And so their argument sort of was that the right to farm statute only protects, and I took this quote from their complaint, giant corporations that control contract growers confining thousands of animals. And so they said that the right to farm statute in Indiana violates due process and equal protection. And so the argument there is that they are treating certain people differently. So here, they're treating ag operations differently than they would other groups. And they're saying that because a neighbor does not have the right to challenge the actions of a farm in court to file a nuisance suit, that violates due process. This case is still pending. They're in the discovery and the motion phase. So we'll kind of keep an eye on that and just have to see what happens. The other recent constitutional challenge to a right to farm statute occurred in Missouri. Once again, we are dealing with a swine farm. You're kind of seeing a pattern here. Plaintiffs here sued Cargill Pork and Boar Farm over odor again. It was about a 4,000 head facility. And once again, Cargill Pork was the contract. The Boar Farms had a contract with Cargill Pork in this case. So here, again, they challenged the constitutionality of the right to farm statute, the violation of equal protection and due process. But here they also argued it was a taking of private property. So essentially the argument was that the right to farm statute resulted in a taking of the neighbor's property rights. The Missouri Supreme Court found in favor of the farmers, interested in reading the entire opinion, I'm happy to get you a copy of it. But the key rationale there was that the right to farm statute was passed based on a legitimate state interest. And that interest was protecting the agricultural industry. And so those of you who are attorneys remember those levels of scrutiny that we look at from law school. So basically, if you're passing a law that's not dealing with a protected class like race or national origin, or even gender is a little more protected, if you're dealing with economic interests, so long as you have a legitimate interest in making those classifications, those are generally going to be upheld. And that's what happened in Missouri. So next up, we're going to look at, does the Right to Farm Act protect the right to grow genetically modified crops? This one's pretty interesting. In Oregon, there was a county back in 2014 that passed a local law that banned growing any genetically modified organisms or GMO crops in the county. There were about 8 alfalfa farmers who grew Roundup Ready alfalfa, so that's a GMO, and they had been growing this for years. They had alfalfa in the field, and so they filed a lawsuit. And part of their lawsuit was it violated the Right to Farm statute if you ban their ability to produce crops. And importantly, the Oregon Right to Farm law says that any local government regulation that makes a farm practice a nuisance or a trespass is invalid with respect to that farm practice. And they have an exception, which is going to be important, for damage to commercial agricultural products. So this lawsuit was filed in federal court, and the district court held that the Right to Farm statute did not apply in this case. It said that the purpose of the Right to Farm statute was to protect from urban encroachment, not to protect one particular farming practice like growing genetically modified crops. And in reaching that decision, they relied on that exception that says that there's an exception if there could be damage to commercial crops. And what they said here was the purpose of the ordinance was to prevent genetic drift damage to neighboring non-GMO farmers. So what the court said is the reason that the voters passed that ordinance was they didn't want, if you were a non-GMO farmer, they didn't want the danger of genetic drift damage. And so the court said that exception applies. The Right to Farm Act statute does not protect those farmers. Eventually, the farmers settled the case here in the last 6 months or so. The settlement provided that they can continue growing their genetically modified alfalfa for the next 8 years. At that time, they will no longer be able to. They have to notify the plaintiff's attorney about where the crops are located, and they have to harvest those crops before a certain time to reduce the chance of thrift. Real briefly here, we're going to look at the Right to Farm statute protect the growing of marijuana. And I have to tell you, when I went to school and decided to be an ag lawyer, this is not a topic I really thought I would touch on. But here we are. So in Oregon, the marijuana use was legalized in July of 2015. And so local lawmakers were looking at passing regulations related to growth, things like, where it can be grown, zoning type things, dealing with odor. And some of those local lawmakers feared that they couldn't pass those regulations because of the Right to Farm statute, which prevented certain regulations limiting growing crops. Just last month, the Oregon governor signed a bill that allows local governments to create reasonable regulations on where and how farmers can grow marijuana regardless of the Right to Farm statute. So here everybody was concerned enough that there could be an argument that the Right to Farm statute would apply. The governor actually, or the legislature and then the governor signed a bill making clear that it would not. One thing to note here, Ashley mentioned this earlier, most statutes have an exception if the farming activity violates state or federal law. So likely, even if you're in a state where marijuana is legal, growing it would still violate federal law, and that would probably prevent protection for Right to Farm for marijuana growers in most states. And then 2 real quick things on the legislative amendments. New Mexico just recently passed an amendment to their right to farm statutes, and this sort of came up. The agricultural industry in New Mexico pushed this legislation after there were 11 nuisance lawsuits filed against dairy farms in the state over the last couple of years. And the new language, which is added to the New Mexico right to farm statute, the big change is there in bold at the bottom. In order for a facility to be considered a nuisance, it has to have substantially changed in the nature and scope of its operation. And so that's, obviously we talked about before, a change in the nature might be something like you go from row crop farming to raising livestock. Change in the scope might be the size if you went from a 500 head dairy to a 1,000 head dairy. But now under New Mexico law, you have to have a change in both in order for the previously established ag operation to potentially be considered a nuisance. And my last piece here is I think it's interesting, probably because I live in Texas and we're surrounded by these wind turbines. But in 2014, the Michigan legislature considered a bill that would have added wind farms to the definition of farming activities that are protected by the Right to Farm Act. And this is interesting because, this isn't something you normally would think of as being a farming activity, although certainly lots of farmers are benefiting from wind leases on their property. That bill died in the committee in Michigan. And interestingly as well, the Michigan Farm Bureau opposed this bill, and they argued that it wasn't the purpose of the law, and specifically they didn't want to weaken or jeopardize the right to farm protection by including any practice that was not directly related to farms. So I thought that was interesting. And now I will turn things over to Paul.
Okay, Tiffany, I'm going to mute my phone now. Or you can just hang up, whichever works for you. And I'm going to talk a little bit about constitutional rights to farm. This is kind of a new development that we've come up with during the past few years. In the past few years, all this is working now. And don't forget that if you have questions, please type them in the chat or the question box. And Tiffany and Ashley have kind of highlighted right to farm laws as they exist now. And we've kind of talked about how they're a traditional sort of nuisance defense. And we're seeing more and more states, I say more and more, so far we have at least 2 states with them that we're going to talk about. One looking at one on the ballot this fall, and then other states have kind of looked at them, but we haven't seen much movement there. But we are seeing this movement towards states looking to add constitutional protections for farms inside their state constitutions. So, and the idea is we're moving away from this broader nuisance defense. We're going to talk about what constitutional amendments are here in a minute, to something that's a little more broader, that's going to provide potentially more protections than just against nuisance suits, to something that's going to provide potentially something to protect farms from maybe environmental laws, maybe animal welfare statutes. It's not entirely clear how broad these things could be in the end. We have very few court decisions, and as I keep looking at them, I see it more as moving it up with sort of other freedoms we put inside constitutions and other areas. So let's talk a little. Oh, my little fancy deal didn't. Well, my little fancy pyramid was there, and the copy of the presentation is available down here where you can click on and get to it. But I put in a copy of a pyramid where if you look at a pyramid and you have the top, you have constitutions up at the top. Down below that, you have statutes, regulations, court rules, and then at the very bottom would be court decisions and agency decisions. For any attorneys out there, I apologize for how basically simplistic I've made the hierarchy of laws, but we have state constitutions, up at the top. This is going to trump a lot of state laws, state statutes, state regulations as to how they're going to impact farms. Not sure why that didn't show up there. So currently, where are they at? Well, currently they're in North Dakota's and Missouri's constitutions. North Dakota was the first state to pass it in 2012. Missouri passed it in 2014. Missouri's came about after, in the previous election in 2012, animal welfare groups had some animal welfare statutes added in that potentially were going to impact a lot of farmers. And the Missouri's deal was a way to limit some of these outside interest groups coming in and putting additional regulations in on farms. States considering them as Oklahoma's will be on the ballot in November of this year for vote during the presidential election. And then Nebraska, up until a few weeks ago, was considering putting one on the ballot. And then Indiana in the past has considered these. If anybody's on here from Indiana, you can tell me what the current status is. I would like to know. I haven't seen anything recently on it. So let's look a little bit at the language on these things. So North Dakota's, the idea here is, it protects the rights of farmers and ranchers to engage in modern farming and ranching practices shall forever be guaranteed, and there can be nothing that goes to abridge the right to employ agricultural technology, modern livestock production, and ranching practices. North Dakota's talks a lot about utilizing modern practices. We move to the other end of the spectrum with Missouri, the other state that currently has one of these enacted. And I highlighted sort of language to look at there. There it doesn't speak towards modern. It just says that the right of farmers and ranchers to engage in farming and ranching practices shall forever be guaranteed. And sort of Oklahoma says the same thing, that we're going to, protect these rights for them to engage in their practices. But at the same time, it points out that the legislature cannot pass laws that abridge this right when they employ technology, livestock production, without a compelling state interest. One of the interesting things that's going on in Oklahoma is because there is a debate that would water quality or other environmental laws be a compelling state interest. The legislature is actually looking at going back and adding into the some of the environmental statutes that this is a compelling state interest, and the court should respect that and allow these laws to stand against farming and ranching. We don't know how that's going to play out at this point because the statute or the constitutional amendment has yet to pass. Uh-oh. So comparing the languages, what do we have here? Well, we've kind of brought this up, and I've kind of pointed this out as we taught. North Dakota kind of has this requirement in there that it has to be some sort of modern practice. Issues that could arise with this, what if you have a group that has religious implications that does not want to adopt quote-unquote modern practices such as, the Amish or other groups that utilize more traditional methods? Would they still qualify under this? That's a good question. I don't know the answer to it. The other question would be, what about Missouri and Oklahoma where it doesn't include that language with modern? Would there be a limitation placed in there where that people have to adopt this, or would it be broadly opened up to any type of practice being forever guaranteed by the state? We're going to talk here in a minute. Missouri has had some cases, at least one case, where we've seen how this is going to be limited in some cases. So what does this all mean? And I put my picture up there of the late Justice Scalia and Justice Ginsburg. It means in the end, potentially justices and judges are going to start laying out the groundwork as to how these amendments are going to play out, how they're going to either limit or expand the rights farmers have. We're not exactly sure how that's going to play out at this point. We know it's going to have to potentially go through the legal system, and it may not go through the legal system. It may actually be a barrier to where people don't actually want to bring claims. We don't know at this point. They're too new to actually have any ideas as to how these are going to play out. At this point, we do know that Missouri does not allow for the cultivation of marijuana. Right after the amendments passed, a couple of people who had current pending criminal cases for being busted for growing marijuana in closets or other areas of their house basically said, this new amendment, this right to farm amendment, says the state cannot infringe on my right to grow marijuana. And the Missouri courts were quick to say, no, that's not actually the case. We still can restrict your right to grow marijuana. And, as I say, there's still going to have to be litigation to determine the boundaries of these things. I think they're too new at this point for us really to understand what some of the boundaries are going to be and how it's going to impact environmental and animal welfare and other statutes that impact ag, issues we don't have to deal with when we look at traditional right to farm laws. The other thing to point out is they're not going to trump federal law, the federal constitution in the hierarchy of things. So there's still going to have to be compliance with federal laws and federal regulations such as the new WOTUS rule, RCRA, the Clean Air Act, etc. One of the more interesting debate points with Oklahoma has been some of the groups opposed to the state question with the right to farm amendment have actually come out and said, are you opening up the state to potentially the federal government coming in and regulating these areas? That's another area where we're not really sure what all is going to go on there. But it is a potential area. So it's going to be similar to other constitutional restrictions that as those that are attorneys here and gone through law school, we've learned that, potentially we may think we understand what a constitutional right is, but then the court comes along and it further clarifies it, further explains to us what it is. So we may be looking at something to where we think we know what we're talking about, but we may not totally until courts get involved. And the litigation, as I keep talking about, is going to start telling us more and more bounds of the areas of these right to farm amendments. So sort of to wrap this up and to leave the last 15 minutes for questions, constitutional, right to farm amendments are going to offer much more broader protections than right to farm laws do. There's going to be a much more broader implication to animal welfare, environmental, zoning and planning issues that could arise under these things than just a traditional nuisance defense. But at this point, it's really too new for us to know how they're exactly going to impact all of this. So thank you guys for participating today, and hopefully on the next slide, if I click it right, yes, all of my contact info is up there. So if you have any questions or we don't answer something, please send us an email. And if you have any questions, please type them in the box. We did record this webinar. There is an evaluation up there as well. You can tell us, your thoughts on it. And we did provide links to each one of our blogs up there as well, where we all cover each one of these topics, usually in more detail. And I see a question, if I can get that. If I can get the mouse to work. I've read the Oklahoma provision has been challenged in courts. Can you? I can't speak to that lawsuit. I know a little. I've seen it, and I think I can't remember if it was something about it was sort of what Missouri's was. There was a way as to it didn't allegedly follow the proper constitutional provisions in bringing a vote on a constitutional amendment. I really can't speak on it because I don't know where it's at in the courts right now. The last I heard was the judges were hearing it, but I couldn't remember where it was at. But I'll look that up and get back with you.
All right, Paul, and I'll take a question. Sorry, I'm echoing on your end, but it looks like there's a question on what states define generally accepted practices by statute or reg. In my experience, mostly the definition up to industry. They're actually the two off the top of my head that I am thinking of are Michigan and New York, and they set out the GAMPs that have been developed, basically based on manure management and utilization.
I think Ashley is about to get thrown off of here, so I'll keep talking and allow Ashley a second to catch back up with us. Yeah, we don't.
This is Michigan specifically. Pesticide utilization and pest control, nutrient.
Ashley, are you still there?
Utilization, care of farm animals, cranberry production.
You're going to have to start over. We've lost sound too many times.
Okay. So the question was, and it's gone now, I can't see it, but it was which states set out generally accepted practices. The two that I know of off the top of my head are Michigan and New York. And the other question was, don't industry set these standards? Industry can set standards. There are industry standards. These are just the state standards that allow the operation to use the statute to bar the claim as long as they're following these standards. That's the goal of the statute in that. And I don't know, I know there were other questions, but I don't see them now, Paul. Large gardens and small farms. As far as I am aware.
Yep, Tiffany, you're on now.
Yeah, I can take that question that Ashley was trying to answer. Someone asked, are there differentiations in the statute based on the size of the operation, either the number of acres or the yearly income? I'm not aware of any of those types of provisions being in any of the statutes. Now, I know that there was an issue coming up in Michigan because there were some folks who had, I guess they call them backyard chickens or urban chickens, kind of in the city. And so I know that in that case it kind of came up, is this really what the right to farm statute is meant to protect? I'm not sure how that ever got resolved. But like I say, I'm pretty familiar with right to farm statutes in all 50 states, and I'm not aware of any that specifically deal with any sort of size restrictions.
I'm reading Jessica's question right now. And we can open this up to anyone, Ashley or Tiffany, if they want to jump in here as well. But I do not think they would prevent a state legislature from enacting federally required standards, because it's still going to be a federally required standard that you have to enact for certain reasons, such as WOTUS will be a federal standard that will be implemented by EPA in the core, so they're not going to get around that. There may be areas with the Clean Water Act other areas with TMDLs that we're not totally for sure on yet because these are so new, but there may be areas like that where states have more delegation of duty to where they may be able to set up a TMDL in a way to get around agriculture as a result of right to farm constitutional amendments.
And I see a question here from Kurt asking how many of the 50 states have an attorney fee provision. I don't have an exact list of that, Kurt. The best place that I know of to go, if you will Google National Ag Law Center Reading Room, and if you'll go under the Urban Encroachment tab, they've got a map of the U.S., and you can click on every state, and you can pop up that state's Right to Farm Act, and you can look if there are specific states you want to know about and see what provisions they have.
And the next question is, do you see the right to farm GMO crop lawsuits becoming more prevalent, piggybacking on GMO labeling laws and issues?
Yeah, I mean, I think that we're going to see, I think anything involving, GMOs is probably something we're going to see more and more in the courts. Exactly how those lawsuits are going to be brought, how those play out, I'm not sure. For example, I think that if there was a neighbor who didn't like the fact that, the neighboring farm was growing GMOs but couldn't show any damage, I obviously don't think they're going to be able to be successful. And of course, that case in Oregon was unique because there was that local ordinance. Now, if there is a neighbor who's quote-unquote non-GMO and can show that there is some sort of drift damage, if that could be proven, in court, there I think we could potentially see a lawsuit, and I'm not exactly sure, how a Right to Farm Act would come in and deal with that situation, but I think that's something we could definitely see more of.
There's a question TK asked, how does right to farm laws intersect with confined animal feeding operations? And I'm not sure the exact the exact issue, but right to farm laws will protect confined animal feeding operations as long as they meet all the criteria in that right to farm statute. If there is a nuisance or claim brought. I'm not sure if you wanted any more deeper than that, but that's how they intersect.
So Brad's question is thoughts on urban agriculture and efforts to set up operations in town. We deal a lot with this in Maryland. We have a lot more, I think, private urban ag in Baltimore City and areas like that. And the prevailing thought we've had is that these laws do not protect urban ag in some cases, mainly because from the way our statute is written, the farm had to be there first. So it's really hard in a lot of cases for urban producers to show they were there before the city was there. So that's one of the big issues. In some cases, there may be issues in other areas, and I'll let Tiffany and Ashley expound upon those if anybody wants to take a stab at it as well.
I think you explained it well, Paul. I think the
statute issue. Like I say, I know this is a big deal in Michigan, and we're looking at maybe modifying the statute to deal with kind of the urban farming issue, but I'm not sure how that played out. I don't think they amended anything, but that might be something to check out online if you're interested in that topic.
Yeah, it is going to be very state specific on how it's going to implement. And kind of looking at TK's question, how these intersect. Right to farm laws and CAFO regulations are going to interact in potentially just the ability to limit nuisance suits. There's still going to be areas with the environmental regulations, zoning and planning, depending on the state, and other areas where the CAFO is still going to have to meet those. It's just generally directed at limiting nuisance lawsuits against the farm. I see some more questions being typed.
The question Dan wrote is which states include protections for farmers markets or farm stands? The one that I addressed was Hawaii is the one that covers the farmers markets.
I know
I'm not aware.
I won't be able to hear Ashley anymore. I know for sure that Hawaii has that in there. Again, you just have to look at each of the states. I mean, I don't know. I wish there was a chart somewhere. That's actually something somebody should probably do. But you could look at that. I mentioned at the reading rooms for the National Ag Law Center and just click through and see which ones are defined. The only one I know of for sure off the top of my head is Hawaii.
Yeah, that's what I say. I think Hawaii is the only one I know of off the top of my head as well. And I see any guidance or advice on how to formulate the best right to farm law for our state, a chart?
Oh, Christy, I'm going to plug myself here just for a minute. I actually, when I was in law school, I wrote a law review article about advice for people, legislators drafting right to farm laws. It was written like 9 years ago, and I'm not sure how much I actually knew then, but I'd be happy to get you a copy of that if you want to shoot me an email. This is Tiffany.
Any more questions? Well, I see none. I don't see any more, but if you would like, please take a moment and fill out the evaluation. I will send out a link later to everybody who attended with the evaluations. I know we had a couple of people who had trouble logging in earlier. I do apologize for that. We will have a recording of this up later today or tomorrow. I'll send that link out as well with the evaluation. If you want a copy of the presentation, it's up there. And again, a link to the blogs here at Maryland and the blog at Texas A&M are up there as well. and we'll send those out again with the evaluation and the link to the video. But thank you all for attending, and have a good afternoon.